Lyft is currently being investigated into whether a couple of class actions could proceed against it for false and misleading disclosure. Let's unpackage what is being claimed and what needs to be made up for these class actions to potentially succeed. So let's start with what's being claimed. What's effectively being claimed here is that Lyft made false and misleading disclosures in its IPO prospectus. This caused investors to pay a price that was too high for the company, and they subsequently suffered a loss or damage by virtue of having paid too much to begin with. The effective premise here is that Lyft made false and misleading disclosures in its IPO prospectus. Now, let's look at the background to this. The basic background to this is that Lyft's share price has significantly declined since its IPO. So if we look at the share price, for example, it's declined from an opening of around $78 down to a close at the moment of around $58. It's declined quite significantly over that time period. Not only that, but Lyft has underperformed the broader market index. So the S&P 500 index has increased slightly over that same time period, whereas Lyft has decreased significantly over that time period. Now, part of that decrease, of course, could be attributable to other IPO announcements, such as Uber seeking an IPO, but nevertheless, Lyft has declined significantly. Now, a couple of law firms have tried to assert that this decline is not only due to other competitive pressures, but because Lyft made false and misleading disclosures in its IPO prospectus. These disclosures subsequently became rectified, and this rectification caused the market price to decline as the market became well aware of the true affairs associated with Lyft. The specific claim is that Lyft made misleading disclosures about its market share. In fact, it was claiming a 39% market share, which is claimed to be inaccurate, and also it's claimed that Lyft concealed information about a recall of its bike program, which of course would lead investors to erroneously believe the company was doing better than it was. These are just claims, and they haven't yet been made out in a court of law, so it's important to bear in mind that these need to be proved. Now let's look at what needs to be proved for Lyft's share class action to succeed. So for the class action to succeed, a few things to be made out. Firstly, it needs to be made out that there was a false or misleading disclosure, particularly in this case in the IPO prospectus, i.e. the information released had to be false. The next thing that needs to be borne out is that this needs to have been material, that is, it needs to have affected the share price. This is relatively easy to establish if, for example, there was a clear disclosure that rectified the IPO statement. Here one could identify a clear market decline associated with that disclosure. Now, of course, that needs to be proved in a court of law. Now, furthermore, it's not sufficient to simply prove there was incorrect information, but it needs to be proved that Lyft either knowingly knew this information was incorrect or was potentially reckless with respect to the truth of that information. Now, that again needs to be borne out. Often it's done through circumstantial evidence. For example, the fact that if there were multiple layers of eyes going over the IPO prospectus and there was still false information, is perhaps the case that they were at least incredibly reckless about the information that was released. Now, of course, not only this, it's necessary to prove to some extent that investors relied upon these false statements when making the investment. That is, the investors invested based on the information that Lyft released, and they'd made an investment at a price that was too high. This would typically not be a difficult thing to prove, because generally investors will rely upon prospectus information when making an investment in the IPO or soon thereafter. So if we sum this up, basically what needs to be proved is that Lyft A, made false information in the IPO prospectus, B, this was material in nature, C, it was damaging to the shareholders, and also D, that Lyft knowingly knew this information was false, or at the very least was very reckless with respect to the information. Now that's the broad overall scene of what they need to prove. Of course, there are some other minutiae that need to be proved in a court of law, but those are the major things that need to be made out. Now, of course, whether this is successful is really going to depend upon how materially misleading the IPO prospectus was. That is, how far out were Lyft's market share forecasts, and if they were only out by a small margin that was not deemed to be price sensitive, then probably the lawsuit wouldn't succeed. However, if they were clearly making egregious errors in the IPO prospectus, then potentially a lawsuit could go ahead. Now, it's important to bear in mind that the news releases about the shareholder class action were relatively vague in nature. There weren't really specific allegations being made out, and these were really being fleshed out in media reports. So at the moment, to some extent, these lawsuits are somewhat fishing for information. That's not to say they're frivolous per se, but more information is necessary to know whether this lawsuit would succeed. So I hope this has given you a bit of background about the lawsuit that's being alleged against Lyft. As you can see, the lawsuit hasn't got that much detail about it, so at the moment it's not clear whether the lawsuit will succeed. But I've given you some idea about what's being claimed and what needs to be proved for the lawsuit to go ahead. So thanks so much for tuning in, and I hope this has been informative. I hope to see you next time. Bye.